Good morning, everyone. My name is Amanda Ridding. It's August the 12th, 2022. And for those of you who don't know me, I consider myself to be an amateur self-educating student in law. One of the reasons why I become such an advocate on trying to learn and understand the law and then share the information that I am learning is because I believe everyone in Canada, we've been robbed of our knowledge. We've been robbed of this kind of understanding. And because we don't have this knowledge and understanding, we can't identify the corruption in the courts when it occurs right in front of our eyes. So I'm doing everything I can as quickly as I can to learn as much as I can about the law. And now I'm sharing the information through what we are doing, so people can identify what we are doing. And I say to you, if you want to do it, you're welcome to do it. But this is not, I'm not presenting this as legal advice. I do say validate everything you hear from me with your own research and or with someone who practices law, who's certified or licensed to practice law. So I'm going to continue on from my previous story. There's two other videos. This is the third, so you may want to go back to those for the backstory. But on August the 3rd, I submitted 3 motions to Quash, and I submitted a letter with it, which I went through in the second video. So on August the 5th, I received a letter from the Crown Attorney's office, and this is in response. The letter that I received is in response to the motions to Quash that I submitted on August the 3rd. And it was in response to the letter that I wrote that I attached to the motions to Quash that I submitted on August the 3rd. So on August the 5th, the Crown's office sends a letter and says, "Good afternoon. Please be advised that the Crown's position for Pebbles and Fred Flintstone is as follows. For Pebbles, the Crown is seeking a control order. Please see attached control order. And for Fred, the Crown is seeking a fine." And they say the amount. Now, again, I've redacted information because these charges aren't against me. These charges are against friends of mine. And I am going to respect their privacy. They have the right to privacy, but they've given me a consent that I can at least share the other information because I need people to see what's going on. The email then goes on and says, "The Crown's position is that either this resolves on the next court date or we set down for trial on the next date. The Crown is prepared to proceed." So right off the hop, they've given an unacceptable resolution because they've yet failed to address the fact that they are violating the recognized protected human rights and fundamental freedoms of the defendants. And in such, they have violated essential elements to commence a proceeding, and they have violated essential procedure components to commence a proceeding. Then they threaten them. This is a threat. The Crown's position is either this resolves on the next date or we'll set down for trial. So you either accept this or we're going to trial. That is a threat. They've just threatened us. Then it goes on to say, in terms of your motion, the Crown will not have the capacity to hear this motion on August the 11th, 2022. The court will not have capacity. I'm sorry, since when does the Crown Attorney's Office have control over the court docket? They're supposed to be 2 independent bodies from each other. Yet the Crown is speaking on behalf of the court, telling me that according to the Crown, the court doesn't have capacity to hear the motion. They then go on to say, your matter is one of many on the docket. Again, the Crown and the court are supposed to be separate independent bodies from each other. Now, I presume that the Crown has many items on the docket. Maybe that's how they know that there's a lot of items on the docket, but still, it does leave some question as to why are they speaking on behalf of the court? They don't have the authority to speak on behalf of the court. They only have the authority to speak on behalf of ironically, Her Majesty the Queen, who the court also happens to be. So maybe they are speaking on behalf of the court. Then it goes on to say the court already heard a motion to dismiss/quash. Stop right there. We did a motion to withdraw or dismiss. They're now trying to call it a motion to dismiss, adding the /quash. And what they're trying to do in the email is they're trying to recharacterize the nature of the matter that was before the court on June 8th. That is an act of deceit. It is an act of deceit to try and make us believe that we don't have a chance to have a motion to quash be heard. So the court has already heard the motion to quash, to dismiss / quash, and it dismissed your application on June 8th by Her Worship, Justice of the Peace, XYZ. Now that part I've taken out. So it acknowledges that it was dismissed. It acknowledges that there were rulings on the June 8th application, and it acknowledges that the Justice of the Peace gave rulings on an application for, guess what, folks? An application that the Justice of the Peace never had authority over. And because the Justice of the Peace never had authority over that application, the Justice of the Peace didn't have the authority to issue a ruling. But here we have it right here in the email that it has been dismissed by the Justice of the Peace. Guess what? And if she hasn't been notified yet, she will be very soon. We filed a complaint against the Justice of the Peace for deceiving us and not demonstrating competence in the law, and or committing intentional deceit, deceiving us into believing our motion had been heard. In absence of any rule to withdraw, for a motion to withdraw, in absence of any rule for a motion to dismiss, it's as if it was never before the court, which means the court never had the authority to hear it, yet alone rule upon it. And if the Justice of the Peace doesn't understand that about the law, then that Justice of the Peace shouldn't be sitting on the bench. We then followed up with the following. I have confirmed with an attorney at law that because the motion to dismiss does not exist in the rules of the Provincial Offences Act, it is as if the motion has never been heard and does not exist. The defendants are using the rules of Provincial Offences Act and are now properly establishing jurisdiction in the court for their matter to be heard. Is the court colluding with, is the Crown colluding with the court as to whether or not the court has time to hear the matter? Question mark. Remember I pointed that out? Now, I was in my haste, I hit the wrong button, sent this before I could finish, so I had to then add. It has come to the attention that both the Crown and the JP has failed to demonstrate competence of the law, and by engaging and ruling upon an invalid motion has misled the public, creating a distrust in the judicial system. The first of many complaints have already been filed. We will be presenting our motion, or be given a date to present our motion, or we will be seeking a writ of mandamus to have our motion to quash pursuant to Rule 36 be heard. Quit breaking the law. Yep, I'm getting cheeky with them, folks, because I'm getting tired of them trying to misconstrue and misrepresent the law. We didn't hear a response from them. And then on August the 10th, 10 separate transactions for 10 complaints were issued against the first of 2 Crown attorneys. Okay, and that was the Crown attorney who actively engaged in the fraudulent hearing they allowed on June the 8th. They deceived me and the defendants into believing our hearing had jurisdiction. They didn't just deceive us, they actively fought for the jurisdiction, and the authority never existed because the rule never existed. So when we went into court yesterday, we started in a breakout room, and we had a brand new Crown attorney, never met her before, brand new Crown attorney, and she was very polite with us. And she said, so we understand that you want to do a motion to quash, even though you've already had a motion to dismiss. And I said, yes. In the breakout room, I said, we want to do a motion to quash because the motion to rule does not exist for a motion to dismiss, and we've confirmed with an attorney at law that it is never properly before the court, therefore it's never been heard. So we are well within our rights to do a motion to quash, which we are doing. And if it can't be, because this court deceived us into believing, and I literally said that in the breakout room, this court deceived us into believing that our motion had been heard when it had not. No problem, she says. But we won't have time today. I know that the Crown has 80 things on their docket. And the docket so people understand is public record at this point. It's usually issued 2 days before the hearing. So the court has 80 items on their docket. So we can just go into the court and ask for another date. And I said, okay, thank you. I appreciate that. And we go into the court. And along with the other things that happened in court yesterday, the court said, so what are we doing today? And we said, well, apparently you don't have time to hear my motion to quash today, so we need a date. And so it was like, absolutely no problem. By the way, we had a brand new Justice of the Peace as well. Very polite, seemed to be far more competent in law than the last one. And Long story short, nobody questioned in the court on the record. Nobody in the court on the record even mentioned the dismissal and the fact that it had already been heard. They acted like it had never been heard. They gave us our date for our motion to quash, which is going to be August the 6th. And they were very polite. They were also very accommodating in other matters, which I've already shared here. But the point is that I've been holding them now to the letter of the law. I've been holding the rule book. I've been taking the rule book and I've been throwing the rule book at them. They also conversed quite a few times, I think on the record, I know it was off the record, that they have been corresponding with their office, and the crown who's taken on the case has just taken on the case and has been corresponding with the office and is now reviewing, they're now reviewing our case. And so the crown is basically trying to catch up here, because don't forget, on the evening before the hearing. So this hearing was yesterday. So 2 nights ago, we submitted 10 complaints with the Law Society of Ontario against one of the 2 crowns in the Crown Attorney's office. Now, when you submit these complaints, the Law Society of Ontario says, just give it to us and acknowledge the fact that we may share the information with the other people. And I said, no, in the spirit of fundamental justice, if I'm issuing a complaint, everyone has a right to know. And therefore, acting in good faith in the letter and spirit of the law, we're CCing the Crown at the same time that we're issuing the complaint. So the Crown has been given fair notice. So I literally, that's what I wrote. We submitted the complaints. We got confirmation the complaints have been received by the Law Society of Ontario, and they were submitted to the Crown and the Crown's office simultaneously. So everybody knows that we know what laws and rules that they are breaking, and we are calling them out on it. And we're exposing the corruption in the courts. So thank you very much. And if you think this information is valuable, I ask that you like, subscribe, and share, because we need to get this information out to all Canadians. Thank you very much.